Good afternoon, good evening. Good evening. It is not afternoon, it's the evening time. Good evening, everyone. Good evening, everyone. All right. Let me add. Hey, Jamie. Hey, friends. Okay, let me add y'all. I think I have seriously upgraded. We about to find out. Um, I'm trying to see what a Monday, okay? I'm trying to see if I can add my moderator. I don't know if I can do it, but I'll figure that out while y'all join. So here's the thing. I'm streaming from both YouTube and TikTok. And while I'm doing that, I know that's right. Thank you on both platforms. So while I'm here, I can't, like, if I'm on my own TikTok, I don't see the live. It's very weird. Why? I don't know. But I can't see my own live. I'm trying to do that now. But it's like I can't see it, which is so strange. So while y'all trickle in, I'm going to try to figure out if I can do it. Like, it would be really clutch if I could. Thank you for sharing, Kelly. Hi, LaShawn. Good evening. Y'all, there gotta be a way to do this. There's no way that I can't do it. I appreciate y'all for being patient with me. Let's see. Y'all are really trickling in. Yes, yes, yes. So for anybody who is not already aware, because it's been everywhere, Judge Glanville was completely removed from the YSL case. So, LaShawn, yes, I do need to discuss that. I'll get into it probably sometime this week. But yes, you're right. It's been one of those Mondays. But we're going to talk about what happened today in the YSL trial. Let us see. I'm trying so hard to figure out. I don't know if anybody in here has ever used Streamlabs that might know how to do this. But hi, Sasha. Thank you so much. Y'all please share, comment, share. If you're on YouTube, subscribe. If you're on TikTok, like and share, please and thank you. All right. Yeah, so I'm supposed to be able to see my regular TikTok chat. And I appreciate y'all's patience because... Oh, no, not tornadoes. Jericho, where you at? Can y'all hear me? Oh, no. Okay, yes, y'all can hear me. Okay. All right, perfect. So I'm desperately trying to get me a moderator on here. I don't know if I could do it from where I'm at. I'm trying though. but I don't see where I can do it. So, but yeah. Let me not tell y'all to drop anything green in the comments before the state of Georgia claim that I'm a member of a gang. Yeah. So, but drop me a red heart if you have read the motion or the order already. I want to know what I'm working with. I kind of glanced over it. I did not read the whole thing. So a lot of this is going to be, I got a fly in here. A lot of this is going to be a first time reaction. Ooh, okay. Y'all been reading. I love it. Love it, love it, love it. Love it, love it, love it. All right. I think we might be ready, y'all. Okay, so I promised my folks on YouTube that I would be able to see y'all's comments at the same time. But it turns out I can't. I'm sorry. I'm so sorry. So if you are here from YouTube, I'm still working on it. But all right, we gonna get started. Let's do it. All right, so I'm gonna just start from the top. This is the order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including one, defendant Diamante Kendrick's motion to recuse Chief Judge Earl Glanville, filed on June 12th, 2024. Caleb Bumpus' motion to quash the show cause order or to recuse Judge Glanville. And number 3, defendant Jeffrey Williams' motion to disqualify/recuse Judge Glanville from all further dealings in the above referenced case and amended supplements. All right, so we don't need to read unless it's Brian Steele's footnotes. I don't really care to read them, but it's just an explanation of what we already know. So let's get into it. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. I just want to point out, I really do think we are moving in the direction of using YouTube. I mean, we're here already. Using YouTube in official court hearings is happening already. This is probably the third judge in this case alone to cite back to YouTube. So that's exciting, and hopefully it encourages way more people to let us stream in court. All right, having considered the record evidence and applicable case law, the court finds as follows. Findings of fact. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to state's witness Kenneth Copeland, which we all affectionately know as Woody. All right. Hold on. Are y'all hearing feedback or anything in my background before I get too deep in this? Let me know. Do I sound fine? How does my sound? Okay, we're good. All right. Yeah, listen, LaShawn, this fan is going to blow. I'm going to find out how to do noise cancellation on this mic, but this light makes it real hot. So I'm going to keep blowing my fan. I'm sorry, y'all. All right. Okay, so we all affectionately know Kenneth Copeland as Woody. On June 7, 2024, the state intended to call Kenneth Copeland to testify. June 7th is going to be the first day that Woody would have been testifying. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. So far, so good. This is just a normal day in court. So we all thought, all of us that were watching thought this was just going to be a normal day in court. After the discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. And I don't know if y'all remember, this is right before he started. He got on and off the stand a couple times, going back and forth to talk to Melnick, getting back on the stand, being sworn in, having questions, etc., etc. After that discussion, Mr. Copeland, once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. So he let him, chill out in the jail basically over the weekend. Even when I heard it, that sounded to me like, let's see how you feel after a weekend in jail. Still, so far, so good. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue of Mr. Copeland on Monday, June 10th at 8:30 a.m. and court was adjourned for the day. Now, let me say this much before we even get any further. This part of the order is okay, I'm sorry. I'll scroll faster, Jasper. But yeah, so the judge is reciting the facts as she learned them, right? So when we talk about the transcript and why what's on the transcript is so important and why letting Brian Steele lay his what's called laying a record is so important is because the judge is not present, right? And we're going to get to the ex parte meeting, but this is the point of having it in why the argument was we should have had this in open court, because now we have this transcript that's 50 plus pages, but we don't know what happened outside of what's literally typed down by the court reporter. There's nothing there. So where you might have Brian Steele, something happens outside in the hallway and Brian Steele will come back in and say, just for the record, I want to discuss XYZ 1, 2, 3. These are all the things that happened. And now something that's off the record is on the record, because even though it didn't happen in court, somebody put it on the record. So there's evidence of it occurring. But in this ex parte meeting, if you weren't there and something was said off the record, there's no way for you to know or confirm it. And that's why partially the transcript was so important. So we know what happened in the ex parte meeting, but also so we know what we don't know. Essentially, we know from this time to this time, there's nothing on the record and we have no idea what occurred. So, yeah. All right. On June 10th at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and standing counsel for Mr. Copeland, Caleb Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland, we don't hear this judge talking about him, about Woody being afraid. I have not heard that come up either. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state, who had joined the meeting. During this time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA section 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. Let me see. Let me go back to the comments just because I already have an opinion about something, but you know. Yes, April. We kind of just got started. We're just reading through the motion. We didn't get into the meat of it yet. So you're not too late. You're not too late. All right. After the meeting and immediately before Mr. Copeland was brought out to testify, defendants Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. Now, like I said, I kind of scanned through, but let me tell y'all something. The judge did what we call split the baby. And I'll every time I hear it, every time I see it, I'll point it out. But the judge absolutely split the baby. And splitting the baby in this case looks like she came to the right conclusion, but not for the right reasons. Just, I need to hydrate myself before it come out, okay? But yeah, she split the baby. She came to the right conclusion without coming to the actual conclusions that we need to solidify what we all know, what we all have been talking about. Okay. Before I get too deep into it, let me get a little deeper into before I get too deep in my opinion, let me get a little deeper into the order. All right. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, set in July 1st, 2024, for an in-camera review of the transcript of the ex parte meeting. So the in-camera review, that's just a meeting that's outside of the public's eye. So it's kind of like an ex parte meeting, but we're the public are the ones that are X'd out of the meeting. So all the lawyers are there, but the judge is essentially reviewing something that he wants to determine whether or not it should be released. So that whole argument they were having about this secret meeting where the public wouldn't be there, where they argue about the transcript, that's the in-camera meeting. The first motion to recuse filed by Diamante Kendrick on June 12th, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertion of fact to support the allegations of bias and partiality. Just a quick little, legal lesson, right? There's 3 things that you need to have somebody recused, right? And she's specifically talking about them. It has to be filed on time. I believe it's 5 days in Georgia after the incident occurs. It has to be filed on time. It has to be supported by a sworn affidavit. In this case, the lawyers, all of them were submitting sworn affidavits left and right. And then it has to be factually sufficient. So it has to allege facts that, if they are true, mean you should be disqualified. We heard Judge Glanville say that it met all of the standard essentially, but he was lagging a little bit on the last one, meaning it contains assertions of fact to support the allegations of bias and partiality, right? But he took it a step further, and I think this is where the judge is about to get him at. Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. Respectfully, Judge Glanville, you are out of line, and that's why we're here. You're out of line. It should not go further than you determining that what's on that paper is legally sufficient. And I don't think he did this on purpose, but we're going to read in the motion where essentially the judge kind of gives him an out, and she uses what he did over and over and over again as the basis to recuse him instead of what he actually did that was wrong. Let me see, did I miss anything? Let's see. While y'all are here, go ahead and like and share the live. Let me make sure I didn't miss any juicy comments, y'all. The best part of the live is definitely the comments. All right. All right, so yeah, this is going to be his problem in the end, and our problem too, but we'll talk about that in a minute. Okay, so essentially Judge Glanville said, yeah, it's technically sufficient, but it ain't true, and you can't prove that it's true, and he's not supposed to do that. On June 14, 2024, Caleb Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from the alleged disclosure of the ex parte meeting. On June 17, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole, here goes the shade. Divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Okay, so what is this judge saying? She's saying that everything that we like about Brian Steele is too much. That's what she's saying. So she's saying that outside of all the extra drama, yeah, Jamie, I don't like that she said that. It bothers me because he's advocating fiercely for his client, and it waters down how problematic, her saying that waters down how problematic this ex parte meeting was. And we'll get into it in a minute when we get to that point, but so far she's the only person that has essentially said that the ex parte meeting was not that big of a deal. Nobody else has said that. Yeah, it's a red flag. It's definitely a red flag. Definitely a red flag. Yep, I agree. So, all right, let's see. Let's see. All right, Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters with the ex parte meeting. Back to what we just talked about on the prior page. He's doing too much. And I don't know if I went live and I talked about this or it's in a video, but we definitely discussed how he was trying to cover himself. He spent like 45 minutes basically laying his own foundation, laying his own record about everything that he wanted to make sure that's okay, LaShawn, that any judge hearing this heard. He laid out case law. He talked about the facts. He talked about what did happen, what didn't happen, etc., etc. He essentially, let me not give too much. Let me finish reading it. Sounds like she is doing him a solid for what probably will be a disciplinary hearing for the judge. So I don't think we're going to get to the point of a disciplinary hearing, honestly. I don't think there's going to be any, well, I don't know. Brian still be mad enough to do, who knows? But I don't foresee any of the attorneys filing like bar complaints or anything against the judge. I don't know. Maybe they will file like JQC complaints and whatnot. But she's definitely, thank you, Valerie. She's definitely giving him an out. Like, she's coming to the proper conclusion without nailing him. And that's the problem with having a judge who works with you and who does not have as much leadership, I'll just say, in the area, right, in the courthouse as you do. That's the problem with having a judge that works with you hear this motion, right? Because no, Brian Steele is definitely not going to let this go. Because can we expect her to really lay the hammer down? Like, if in her personal life she really feels like, Judge Glanville, you know, this was bad, you are unethical, you should have not done XYZ, can we really expect her to go that hard? Can we really expect that? I don't. Right, she's doing her best. She's doing her level best to help him and toss him a lifeline. I agree. I don't know. I don't know if they will or not, but after reading this, I'm just like, we'll get into it. All right, so most of what Judge Glanville relayed was a collection of record evidence about the recent circumstances of the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance footage, which none of us believe. Nobody believes that he didn't go and say, bring me that damn footage. I want to know who met with who. I want to know who said what. We don't believe that. We don't believe that. Like, nobody believes that. We all know that you went back immediately and said, oh, Brian, you don't want to tell me, Mr. Steele? You don't want to tell me who told you? I'm going to find out who told you. Please. Please. Yes, Jamie. A big old floaty. Okay? She threw him a big one. You know, if Brian Steele, Michael, if Brian Steele is anything like what I think he is, he enjoys advocating way too much to be a judge. Maybe later, further down in his career, but it seems like he really enjoys the action of being an advocate. All right, Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Nah. Respectfully, Judge Krause, no. Absolutely not. I don't even know how you could come to that conclusion, that nobody gained a tactical advantage. You gave the state an opportunity to meet with this witness, surround him, right, with investigators, police officers, correction officers, the judge, that you gave him. And, you know, this is no shade to Ms. Bumpus. I think she's a great attorney, but not the attorney that was familiar with what was going on. He was in there with a stand-in attorney, and no matter how great of an attorney you are, it's just never the same when you haven't been. I don't know if she was watching the trial and saw what happened on Friday. So it wasn't like he was in there with an attorney who was aware, and I'm assuming that she wasn't aware specifically. And you can kind of tell from the transcript that she wasn't aware of everything that had happened. So he's in there with a stand-in attorney who does not know that any of this is about to happen. the judge who's telling him, I'm gonna throw you in jail, the state who's telling him, we gonna ask the judge to throw you in jail and he's gonna agree with us, investigators, like all of these people, and he's in there, afraid is a loose word, but essentially unfamiliar with what's happening and what he should do, and trying to figure it out and making statements that are critical for the defense. How are you gonna say that nobody got a tactical advantage? Not a fat face on lie. Sasha. That is funny. Right. Glanville absolutely said that. That nobody got a tactical advantage. Of course you're going to say that. Because if the opposite is true, then you know we all fucked up somewhere. If the opposite is true and that the judge did something that gave the state a tactical advantage, the case is dead. Point blank, period. Like, it's a mistrial. Because how do you correct that? So, yeah, that's a joke. That nobody got a tactical advantage. That's a joke. All right. Judge Glanville also questioned defendant's right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. And of course, we know once they got assigned to Judge Krause, they started filing motions to recuse her as well and recuse all of the judges in Fulton County, which did not work because here we are. All right, legal framework. So that what we just read is Judge Krause's understanding of the facts based on whatever the record that she has in front of her. So she knows nothing about what was said between the judge, Woody, or any of the state attorneys when they were off the record in the ex parte meeting. She only knows what was on the record, what she could see on the video from YouTube, assuming that she watched that. So that's just how she understands the facts. Yeah, she was not about to let them no, this would have been bad. If she would have came down on the judge like every other attorney that I have watched or talked to personally about this, it would have been a bad day. And still a bad day, right? We all saw it. To a certain extent, it does not matter what these people write, what these judges say. There's in your gut, you just kind of know something is wrong. This is one of those situations. All right, legal framework. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. Let me hydrate y'all. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. And this is just a citation. The affidavit must be definite and specific and describe circumstances of, and this is the standard for essentially the bias that will lead to a recusal. Circumstances of extrajudicial conduct or statements which demonstrate either bias in favor or any adverse party, or in favor of any adverse party, or prejudice toward the moving party in particular, or a systematic pattern of judicial conduct towards persons similarly situated to the moving party. Now that would not apply here, but I find it interesting that that's a part of it because we've all seen Brian Steele over and over and over again talk about how he believed that Judge Glanville was biased towards him and towards Young Thug. I don't think that applies here. I think that is referring to over cases, right? And over people, a systematic sort of bias towards a specific group of people. This is like a constitutional standard. And we see this kind of verbiage repeated a lot in different like discrimination type standards, which would influence the judge and impede or prevent impartiality in that action. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once a motion is filed, it's the duty of the assigned judge to temporarily cease to act upon the merits of the matter. We heard Brian Steele ask multiple times, Judge, you need to cease to act. You need to stop. We filed it and this motion is sufficient, but, he didn't. He did not. All right. So, once a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. If all three criteria are met, i.e. the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall. It's one of my favorite words. It's not a big word, but it's a powerful word. Shall be assigned to hear the motion to recuse. When I'm arguing a motion, if I write a motion and I'm asking the judge to do something, when I look at the statute, it says shall, you should see me in court. I stop everything. Pause. Such and such and such judge shall. Deep pause. Loud shall. So everybody hears it because it's not optional. It's not optional, Judge Glanville. If you shall, then you shall. It does not, you don't get to do it any other way. And I don't think he got that. I don't think he understands that. Shall absolutely means must, LaShawn. When I see shall, we have a problem. I need everybody in the courtroom to hear me say it. Court reporter, did you get that? Judge, you shall do it. Yeah, y'all drop a shall in the comments. Because Judge Glanville was not, he didn't get it. You shall. Point blank, period. There's no question. Another judge shall be assigned to hear the motion to recuse. Judge Glanville said, I don't give a damn about what I shall not do is follow the law. Not in this case. And so back to my point, what he was essentially doing was undermining the legitimacy of the motion and saying it's not sufficient because he understands if it meets all the criteria, it has to go to another judge. But yeah. LaShawn, touch your neighbor and say, shall. Jamie, I shall call in sick tomorrow. Listen, shall is important, okay? It is important. The legislature does not play. When they say shall, there is no such thing as discretion. You got to do it. Period. All right? All right. So when considering a motion to recuse, the assigned judge should be guided by Rule 2.11, 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall, come on, drop a shall in the comments again, because here we go again. They said shall. Jerica said, Jamie, you better be at home tomorrow. Shall equals period. All right. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Judges shall disqualify themselves. I think I mentioned this. I filed a couple of motions to disqualify. I've actually never had it to be transferred to another judge because for the most part, a judge will disqualify themselves. If there is any kind of merit to it, for the most part, they will. And correct me if I'm wrong, if there's any other lawyers that have had different experiences, but my experience has been, I take that back. One of my really good friends, he tried to disqualify a judge during the trial and she was not having it. But yeah, for the most part, when you allege something, it normally goes pretty well because judges just don't want to have to deal with another judge commenting on their behavior. And it's an extraordinary step to file a motion to disqualify. Like, people don't just walk around doing it. I don't like this judge, I'm going to file a motion to disqualify. That's not how it goes. That's not how it goes. Come on, Jerica. Does this mean they'll get bond? I'm sure the motions will be coming. But I'm going to discuss that in a minute because she gave Judge Glanville I think she gave him a lifeline. I also think she's trying to hold the case together. She's trying to keep the case together. Because quite frankly, if they get a mistrial or a dismissal for any other reason, think about how much money that they spent trying this case so far. I don't know if we're halfway in, but we deep in. We are deep in. All right. The standard is objective from the perspective of a reasonable, didn't we talk about this last time? A reasonable, fair-minded, and impartial person, rather than the affected judge or interested parties. So, Judge Glanville, not from your perspective. This is not about what you think and about what you feel, which, going back, he spent 45 minutes on a tangent talking about what he thought about. It's not about what you think. Respectfully, it's an objective standard based on a normal, reasonable, normal thinking person. Would a normal person, like all of us, like all the thousands of people that follow me and that don't follow me but watch my videos, or follow other people and watch their videos and are in the comments saying, this judge needs to be off this case. I think it's like a common public consensus that he needed to be off this case. So reasonably thinking people, what would they think about this? Would they think this judge is biased? Yeah. I think the motion's already drafted. I told y'all, I heard Doug Weinstein say, listen, we working on it. We're working on scenario 1, 2, 3, 4, and 5 already as we speak. I expect by tomorrow morning when we wake up, there's going to be motions. There's going to be motions. Has jeopardy attached? Yes. So jeopardy attaches once you swear in the jury. So jeopardy has attached. The real question is whether or not, if this case is ended, it ends in a way that causes there to be double jeopardy if the case is tried again. So once the trial has started and the jury is sworn, jeopardy attaches, but that doesn't automatically mean that there can't be another trial for some reason. But I'm 100% sure that Brian Steele, Doug Weinstein, I always say them because they're the ones that file the motions the most, but they're all going to be arguing that this is a double jeopardy issue. All of them. All right. Okay. Where was I? Shall. Okay. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must. Let's talk about synonyms. Because shall also equals must. Now, it's not me saying this, it's the law. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. Give me a hell no if y'all think, if y'all agree with me that Judge Glanville did not do that. Give me a hell no. Because it definitely says must. It says that must be reassigned. Give me a hell no, because he did not. And opposed, yes, Asia, and opposed it, aggressively opposed it. Opposed it for about 45 minutes. He opposed it aggressively. And I'm gonna tell y'all now, this is pretty much where I got. This is probably the end of the part that I read. I didn't get much further after this. It's only like 2 pages, but I didn't get much further after this. But no. Yeah, he said exactly, Jericho. He said, let me just tell y'all something. And I think at that point he probably was like, look, this is probably gonna be the last time I get to speak on this, so let me just get it all out. Let me just say what I got to say. That's my guess. All right, we are at 3,000 likes. My last live, we got to like 10,000 likes. I'm trying to make it back there. So y'all do me a favor, like. What else can you do on TikTok? Share, like, and share. Please, please, please. It's like when you tell it, right. Look, respectfully, I want the best for you, Judge Glanville. I want the best for you. That's literally what she's doing. That's exactly what she's doing. Like, look, Judge Glanville, look, I'm not gonna lie. I'm not gonna lie. This order basically says, look, I'm gonna be honest with you, you fucked up. But I'm gonna give you some grace because I think your heart was, I think you had good intentions. That's what this order says. That's what it basically says. Come on, Asia. We getting there. She could have gone in. I think she should have. I'm not sure. Jay, I'm actually not sure. I think he was a JAG lawyer, if I'm not mistaken. I know he's been a lawyer and or judge for over 20 years at this, so he has significant legal experience. I'm not sure how long he's been a judge, but I know he's been in the legal field for a very long time. Yep. All right. I'm going to read that one more time just so we can. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations. Back to what I was saying. The judge is supposed to accept the allegations as true, even if they are not, right? You all you're saying is, if this is true, it's enough to get me off the case. You're not supposed to, because what happens, right? If you start defending yourself, let's say we thought that Judge Glanville, we thought Judge Glanville, okay, we might make it out of this okay. Maybe he could, maybe he should stay on the case. Now that you went out of your way to say, I don't give a damn what y'all say. I didn't do nothing wrong. Y'all don't know what the hell y'all talking about, etc., blah, blah, blah. You spent 45 minutes going on this tangent, and I got video, Miss Bumpus, blah, blah. Now I really don't think that you can defend yourself. I really don't think that we can defend our client while you're defending yourself. Because now I believe that you are more concerned about how you look in this case. I can't expect you to make decisions solely based on what the law says. Because now I've called you out on something and I know that you vehemently disagree with me. So, yeah. Right. You are the conflict of interest at this point. You are a witness. You're a witness because you were there, right? You're the judge in the case, and now you're an advocate because you're advocating for yourself. You can't do everything, Judge Glanville. You got to pick one. You can only do one. You can only be an advocate or a witness or the judge. There's only one. Everybody has a role, and it can't be everything. Can't be everything. Yes, he can absolutely be. And I want to talk about that too, Jamie. Like, what's going to happen if this case just proceeds, right? Because they're absolutely going to be able to discuss to a certain extent what happened in this ex parte meeting. To a certain extent. And I expect the state is probably going to be filing motions to limit what and how they can discuss what happened in this ex parte meeting. Not you shall take a comfort break. Y'all are funny. Yes, Jerica, he could not remain objective. He could not. I'm going to keep it a buck, Jamie. I don't think the jury's going to be confused because I think at this point they know. I can't imagine they don't. I can't imagine they don't. Can't imagine it. All right, let's try to wrap it up. Let's try to wrap up the motion. All right. See, I didn't even get this far, y'all. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming basis for recusal. This is the lifeline. This is the actual lifeline. This sentence is the actual lifeline. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. Judge Krause is saying she's really not even, and she's saying, look, I'm not really gonna say whether or not what they originally filed this motion for is a basis for recusal, but what you did after they filed the motion, you trying to defend yourself, that's definitely basis for recusal. So she's saying, forget the initial part, forget the actual motion itself. I'm not really going to address that. If she is going to address it, she's going to address it in the next page. But you can't defend yourself, because now in you defending yourself, you have become biased. Because at the moment you start defending yourself, your primary goal is you defending yourself. It's not justice. It's not being impartial. It's you defending yourself. So now they do have a basis to recuse you. Yes, 10K. I know that's right. Thank you. I appreciate y'all. Definitely appreciate y'all. I'm going to recuse instead of saying he is or is not wrong. Exactly. So I'm going to get to the right conclusion without impugning him, without chastising him. And look, it's not common that judges get chastised, right? And that's part of the problem. They are very used to moving and making decisions without anybody really being able to check them, especially like this quickly. If you notice, Judge Glanville kept saying, you can appeal it. You can appeal it. Because is Judge Glanville going to care 10 years from now when an appeal comes back down that some judge said, oh, in this ex parte meeting? No. But that like instant, like we've all been talking about this every day, that kind of check, judges don't get those kind of checks. They don't. Nobody checks them that quickly. Thank you. Unapologetically, what's your name? I'll be trying to call people by their actual names. Dead wrong. He was dead wrong. Right. Portia. It's like Judge Glanville would have been better off sending the initial motion for recusal off. Let me give my honest opinion. I immediately thought he should be recused, but were we going to find a judge to actually recuse him? I wasn't sure. I didn't know if we were actually going to get somebody to recuse him, even though I thought he should be, because like everybody, you know, these are judges and they yada, yada, yada. If one says one against the other one, maybe it looks bad. This is why Doug Weinstein filed this motion, to make sure that nobody in Fulton County was able to hear it, because this is what he was afraid of. The watered down version of the recusal. So yeah, had he just sent off the motion, ain't it ironic though? Had he just sent off the original motion to recuse, they might have just said, yeah, no, it's not that big of a deal, and not recused him. But by him holding on, he was so afraid. It's super ironic, actually. He knew he did something wrong, and he was so afraid that somebody was going to say that he did something wrong, that he did something wrong-er and ended up getting a result that he might have not had gotten had he just done the right thing the first time. Janae. Yeah, that's crazy. Yeah, I really didn't, Asia. I didn't think anybody would do it. Absolutely 10. National TV, YouTube, Twitter, Instagram, the way that the public, and it's so powerful. It makes my skin, I get like butterflies and what do you call it? Thingies on your skin. When your skin, yeah, the hairs stand up on my arm. The power of public opinion and persuasion is really amazing, because none of this would be happening, I don't think, if this case was not as publicized. Goosebumps. Thank you, April. That's what I was thinking about. No, I didn't go over that yet. It wasn't really denied. It was just, I guess technically it's denied, but she just said it doesn't matter at this point because he's being recused. So she didn't specify anything specific. She just basically said I'm recusing him, so we don't need to address it, basically. Yeah, Toby, recused just means that he's being removed from the case. That's it. That's what's next, LaShawn. The request to disqualify the district attorneys. Unless she said something about it on this next page or so, I suspect that we need a ruling on that as well. So I think we're going to hear about that soon. All right. A judge has no interest in sitting on a particular case. Y'all, this is big. This is important. A judge has no interest in sitting on a particular case. Think about what impartiality means, what being fair means, what not being biased means. Does it matter what judge is on this case? No, because every judge is supposed to be fair and impartial. So you don't have any particular interest you shouldn't have any vested interest in this case. So if you did something that stepped outside of the bounds where you should be and you need to be recused, it really shouldn't matter. It shouldn't matter because you shouldn't have any personal connection to this case. That is the goal of impartiality. That's like the stand. That's what you should be. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. And we all felt it. We all felt it. When he went through that whole, and I got the video, and just so you know, the video wasn't for this purpose, and this reason, and that reason, and that was 45 minutes of him defending himself. Him saying that me and what people think about me and whether or not I get recused right now, that is my priority. That's what that whole little colloquy did for me. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy, which persists after the motion to recuse is denied. If I call you out, if I say, Judge, you need to recuse yourself because you did something, et cetera, and your response to me is to argue with me about it, how can I be sure that you don't hold that over me for the rest of the trial? How? How can I be sure? Yep. And I really think, Jerica, honestly, I think that's what did it, right? The whole holding Brian still in contempt and everything he did afterwards to prevent us all. I'm saying us because at this point, this is our case, child. This is all of our case. We all defending YSL at this point. The efforts that he went through to avoid giving us all the information, that made it worse. That made it so much worse. A request for the judge and yes, he actually filed an amended witness list, Jess, and added them as witnesses to the case. Yep. If this case is won, he want his name attached to it. Y'all trying to kick him out. So, and that's the thing, right? These kind of cases can be career changing for everybody involved. It'd be career changing for the judge, definitely the judge. They're the most viewed person. Like, the camera is on the judge 99.99% of the time. The judge, the defense attorneys, the prosecutors, the witnesses, even the damn court reporter. This can be life changing for everybody that's involved in the case. So, he shall be recused today. I know that's right. Will we ever find out who told Steele? No. Nope. Nope. Like, we don't know. Y'all, it's so funny because we all got all these theories. For all we know, the damn court reporter, came out to get something from her desk and saw them all out there, and they said, hey, what's going on? She said, oh, they're having a meeting inside. It could have been just that simple. We really have no fucking clue. We have no clue how he found out. It could have been that simple. Now, I think we have gathered from Kayla Bumpus's lives and posts that she definitely gave much more information. So I think she gave them a clearer picture of what had happened. But I don't think that she's the person who initiated the information to them. I want to know real bad, April. I do, but I don't think we ever gonna find out. I don't think so. The court reporter, Jasmine, she look like she can't lie anyway. The court reporter, she seemed like she's so honest. Like she might have just walked out there and they said, hey, what's going on? And she said, oh, they're having a meeting. Boom. Spot blown up. We don't know. It could have been that simple. It could have been one of the correction officers going to the restroom or something. Who knows? It could have been one of the investigators, right, and walk right back in like nothing happened. Back on the record. Like nothing happened. We don't know. The court reporter definitely likes Woody. They friends. They definitely friends at this point. Yep. Honestly, I would not be surprised if that's how they got tipped off about the meeting, the actual meeting. Because imagine if they go up to Kayla Bumpus and they're like, hey, what happened in this meeting? And that's how all the information comes out. But who knows? Oh, really? Neek, send it to me, please. I would love to read it because I like her, honestly. Yeah, she probably was. Who knows? Or anybody else. It could have been anybody. I just picked her out. But it really could have been anybody. So I'm sure, LaShawn, I'm sure that Kayla Bumpus gave them details. I'm sure that she gave them, specify what happened. The information that he had and the way that Brian Steele was arguing, it was clear that somebody that really understood the dynamics of the courtroom and everybody's roles, that's who told him what happened. The way that he repeated it, it felt obvious that a lawyer had to, or maybe even like a paralegal or an investigator or somebody who understands, that's who told him the details. But how he actually found out the meeting ever occurred, we don't know. Yeah, so Jamie, after reading Melnick's emails where he said he told Miss Love to go fuck herself, he definitely gave, there's no question about it. I'm sure, knowing Brian Steele, look at me, knowing Brian Steele, like that's my homie. He is at this point. But he found out, however, he got the information from Kayla Bumpus, whatever he could, and then he had a conversation with Melnick. Like, he's very strategic. I don't think he just randomly went up to the court and started, talking. He had the information before. Yes, Jess, I think she gave information. We know she gave information because she's on video having a discussion with them right after. But I'm sure they had a thorough, especially in preparation for the motions, I'm sure they had a detailed conversation with somebody that was in there, but also Melnick. I'm sure about it. Why not? Why would they not? Y'all be getting close to 15K likes. Now, if y'all can give me the 20 likes, I would love y'all forever. Whoever knew it was best to tell. Yes. Like, hold on. So it's just that gut feeling of like, why are we here? Something is not right. Brian still will be charging $1K for a picture. Child. I think the stand-in lawyer gave info because she was in trouble for not helping Woody better. So I don't think, I don't know what the legal, I'm pretty sure that Kayla Bumpus has her own firm. So I don't think she has like a managing attorney or anybody that she could be in trouble with. Also, I don't think that anybody expected it to happen, right? It was one of those situations where like, whoa, this was not, I could have never imagined that this happened. And as quick, you can be quick on your feet, you know, but sometimes you're in the middle of something and you're not really, you know, you're not really understanding what is going on until, you know, you can step out of it and see what happened. And again, she's not, had Melnick been there, I think this would have been completely different, because Melnick had already sent a fuck you email. He wasn't trusting anybody. I don't know that Kayla Bumpus knew the intricate details of how like messed up this situation was until afterwards. Yeah. And this is why, back to the point, this is why attorneys don't have people standing in for like substantive motions. If I have somebody standing in, and I don't even like to ask attorneys to stand in for like a plea, right? So I have a client and their case is closing out. We already worked out a plea and everything. I don't even like to ask attorneys to stand in for me to do that, because I'm just always afraid that things are going to go left. Now, if it's something basic where there's no legal argument, where there's no need for you to know the facts of the case, probably, most likely. But anytime where there's going to be a substantive issue that relates to the facts of the case, or is going to deal with the dynamic of the relationship I have with the other attorney, you don't want to, sometimes you can't help it, but you don't want to stand in because of something like this. She definitely wasn't ready to, tactical advantage, Jerica, exactly. She definitely wasn't ready to stand in to be stuck on the case. Yep, stand-ins get hit with stuff out of left field that they know they're not prepared for by shady DAs. Oh, we're at 20K. Thank y'all. Thank y'all so much. I'm pretty sure that's a high. I am pretty sure that's a high. I definitely appreciate y'all. Yeah, she was glad she got fired. If he didn't say this wouldn't have happened, so it worked for the better. Yeah, well, I think it would have happened, but I think it would have happened differently. Like, we wouldn't have had to ask who said what and who, because I think if Melnick was there, it seems like he would have told the judge. Like, nah, judge, yes, I told him. It was me. I said it. So that's the energy that I get from Melnick. That's the energy I get. Thank you, Juanita. I can't help it. I appreciate it. I definitely appreciate it. What's going to happen to Miss Love? Here's the thing. You know what? Let me finish reading this so I can give y'all my full thoughts on this. I'm not sure what's going to happen to Miss Love, because I think that and y'all forgive me, I broke a nail. Forgive me, y'all. But I think that by Judge Krause giving Judge Glanville an out, that Miss Love and, you know, the state attorneys, they also kind of get an out as well. But I'll tell y'all about that after we get through page 10. All right. Okay, so analysis and discussion is the shortest part of the order. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e. that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. All right. This is interesting to me. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied. So she's saying basically, once Judge Glanville told us all, oh, it's going to go to another judge, he in effect is saying the motion is satisfied, right? Like this satisfies all the criteria. The problem I have with this is the problem that I think Doug Weinstein and probably any other lawyers that are reviewing this are going to have. She does not address the obstruction. She does not address how Judge Glanville obstructed these motions for weeks at a time. she doesn't say anything about that. And that's a problem. That's a problem for me. We're definitely going to talk about Alec Baldwin too. We are definitely going to talk about Alec Baldwin because I'm not going to lie, friend, April, that was the craziest shit I have seen in my life. I don't know what's going on in these trials. Let me not say that. Stuff like this happens every day in so many courtrooms across this country. It happens every day. The problem is not everybody is a Young Thug. Not everybody is a Alec Baldwin. Not everybody has Brian Steele. Not everybody has me. Not everybody has a Law and Crime streaming their trials. Stuff like this happens all the time. And you start to notice how comfortable, not just judges, I'm saying in general, how comfortable people are misbehaving and stepping over people's rights because they do it all the damn time and they don't get caught. Or they get caught and nothing happens. Hey, Brittany. Brittany, you are late, girl. We are on page 9 of the damn order. Yep. Yeah, it's a problem. The fact that she's not saying anything about how he obstructed, I don't like that. I don't like that. But you made it, Brittany. You made it, though. Everybody, y'all drop down the comments and say hi to Brittany, please. Y'all say hi to Brittany, please. Every damn day. Prosecutors be trying it every day. That's my sister, y'all, the Earring Effects. Y'all make sure y'all go follow her as well. I'm going to just plug her business really quick. She has beautiful, beautiful, beautiful quality earrings, and I'm trying to get her to sell some other stuff because she has a couple plugs, but she won't do it. So for now, y'all go follow the Earring Effect. If you are a woman or any person that is interested in beautiful earrings, please go follow her. I promise it's worth it. This is the Young Thug, the YSL trial that we're talking about, Lexus. Jerica, tell Brittany you shall be on time. Next time, you shall be on time. She need to say face for herself. If she put that in there, she basically is putting a target on her. But back to, oh yes, 25K. Thank you, Bailey. Come on, y'all. I love this. I love this for us. I really love this for us, y'all. But yeah, that's the problem. That's why they kept arguing this. It should not be a Fulton County judge that hears this because it feels so wrong. We want a judge that's not going to be afraid to say, nah, this is fucked up. And we kind of got a little, we got a little pop. We got a little pop on the hand when we really need to spank on the ass. And that's the problem. That's really the problem. Thank you, Portia. I appreciate it. I don't know no other way to be, honestly. This is the only way I know how to be. Yeah, she didn't want him to put him on. Yeah, and not just, I don't think it's just that she knows him. This is her colleague, right? And she's a judge. She has to face him and deal with him every day. Granted, let me say this. I don't know anything about Judge Krause. Maybe she just really believes what she wrote. I don't even want to take it that far. I just understand how a person doesn't, forget the fact that she's a woman, forget the fact that she's a woman that's a judge, forget all of that, right? Just being a person that is faced with criticizing one of your colleagues, one of your superiors even, because he's a chief judge, that shit is hard. That would be difficult to do even for somebody who is up to doing it. So this really feels like splitting the baby. Yeah, it really feels like splitting the baby. About that, hell yeah. Do I think she gave him a heads up? Absolutely. Absolutely. I guarantee you he knew before we all knew, before it was even filed. Hey, just want to let you know this is what I'm going to be doing. Yep. Well, I wish I could pin that comment. Okay, if anybody, I think it was Carlissa on my last live that was telling me she would help me with Streamlabs. Please, girl, if you watching, send me another DM so you can get to the top, because I got a bunch of DMs today. But also, anybody else who is familiar with Streamlabs and how it works, we got to figure out how I can pin stuff on here and moderate and all of that. Y'all help you, girl. But yeah, you could sentence somebody to life or death, but you're afraid to chastise a colleague. I would pin that if I could, LaShawn, because that was a word. That was a word. Wait, I missed oh, they probably wrote it together. Lord Jesus. You think she sent him a courtesy copy and asked for edits? Lord. I'm sure he got a hey, not a text. That would be, she probably didn't text him. She probably FaceTimed him. So it will be no record of it, of what was said on the call. But yeah, I wouldn't be surprised. All right. Okay, so in transferring cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied. She basically is giving him she's not giving him a pat on the back. She's really just laying out what happened, but she's not commenting on the most important parts of the motion to recuse. I.e. that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It's worth noting that this court agreed. Ooh, child. Let's take our time and read this paragraph. It is worth noting that this court agreed. This is the lifeline. I said that other sentence was a lifeline. This is it. It's worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, Judge Glanville added facts, provided context, and questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Right, Leah. I beg your fucking pardon. Let me take another sip. What is she saying? I guess we knew she was going here from the other paragraph, but she basically said there was nothing wrong with the ex parte meeting. Yeah, he probably could have did it in open court, but so what? That's what she said. This is political correctness. I agree. That's insane. That is insane. It's insane. It's insane. I completely, wholeheartedly, passionately disagree. Yeah, they don't address the fact. Again, this is another document file that does not address the fact that he was a sworn witness. It does not address the fact that that he had already taken the stand. And it does not address the fact that Judge Glanville was obstructionist after all of it happened. Bailey, not one. Judge Krause is, other than Judge Glanville, Judge Krause is the only lawyer that I've seen agree with this meeting. And I'm talking about prosecutors and defense attorneys, right? Because I even sought out prosecutors that I know, hey, what you think? I have not talked to, and I've been looking. Low key, I'm gonna keep it a buck with y'all. I was looking for somebody that disagreed with me so I could go, so we could discuss it on live. I haven't found anybody. Y'all know somebody, drop them down in the comments. I would love to hear the other side. I was looking for somebody to disagree so that I can invite them on so we can discuss it, because I'm really interested in that other perspective. I ain't found nobody yet. Nobody. Piranha Pisces. Let me know your name. I'm trying to call people by their names. Yeah, no, I haven't seen anybody. The whole internet, Janae, the whole internet is on the same page, baby. Beyonce's internet is consistent and on one accord. Period. Danielle, yeah, they're trying to save the case. And this is probably if we don't take anything away from this live, take this away. What Judge Krause did is try to nip in the bud misconduct allegations, right? Because how you get a mistrial or dismissal with prejudice, how you get this case nipped in the bud, one of the strongest ways to do that is going to be with misconduct. We literally, it's like the heavens, right on time. The way that you get it is misconduct. That's how you get the case thrown out. That's how you make sure it can't come back, right? So we saw in Alec Baldwin's case that they hid evidence, and the judge said, what the the judge was like, no, like, are you serious? Y'all did it intentionally. It's very clear, and we can't correct this. Dismissed, don't come back. I don't want to see y'all in my face no more. That's what the judge in Alec Baldwin's case said. Literally. So by doing this, Judge Krause is basically trying to eliminate. Now, it's not going to stop Brian Stilden from pursuing that avenue, but she already told us what she thinks about it. She already said it's not misconduct without saying that. She's basically saying, no, he didn't do anything wrong. The worst thing he did is defend himself. That's what she's saying. That's what she's saying. Not only that, I won't say this is an attempt, but it's definitely, it definitely prevents there from being any, like, public opinion is one thing. Even amongst lawyers, the opinion of judges amongst lawyers is another thing. But when you have an order, let me just give y'all, attorneys talk, right? We talk, we gossip just like everybody else. But there's also like the legal banter that goes on. There's the legal communication, right? So if an order comes out and the order says, Judge Glanville, you engaged in misconduct, you are dishonest, you are obstructionist, etc., whatever, all the things that we wanted to say specifically about this case, that order goes to I have a whole folder right now that I save full of orders about different issues, different topics, different judges that I may need to use later, that I might need to cite to in motions, right? So if I'm in front of a Judge Glanville in the future, this is just a hypothetical. I already told y'all I don't think that Judge Glanville is particularly like corrupt or anything like that. I don't think that he intentionally said I'm about to do something wrong. I think that he did something wrong and then his ego took charge, right? I think that's what happened. But anyway, if I get this order and the order says what we wanted to say, this was wrong, it was unethical, you are biased, etc., etc., I take that motion, I save it, and 6 months from now, I'm in front of Judge Glanville and he does something, that I think is a bias against my client. I'm going to type my motion and it's going to say, and I want 1, 2, 3, 4, 5, 6. And this is not the first time that Judge Glanville has done this. Just 6 months ago in the YSL trial, such and such and such. Citation, please. Please see the attached order. That's what I'm going to do. Right? So it is almost like a little mark on your career. It's a mark. No different than when you file an appeal and an appeal comes back and people start citing cases, using that case in their motions. So it's 30K. Y'all, you know what? It's too much. It's too much love, y'all. Yes, Danielle, I agree. There was a time. I agree. I think this is I think this is misconduct. It has such a negative connotation, right? In the core sense of misconduct, I don't think it requires ill will. I don't think it requires malice. I don't think it requires negative energy, even. But when you do something that is wrong, that is improper, absolutely, that's what it is. It is what it is. Must have been tough disciplining your boss. I agree. I don't think she disciplined him. I don't think so. Okay, can they go back and look at old cases? No, because she's saying it's not that big of a deal. So think about it like this. And I saw I think it's The Lawyer You Know, if I'm not mistaken, on YouTube. He touched on this early, and it was a really good point. So they're recusing Judge Glanville, but not saying that he did anything wrong in any of his rulings or the ex parte meeting. What that means is, let's assume they're going to push forward. They're just going to have a new judge, which is what it seems like now, and push forward with the trial. That judge, because there is no misconduct, according to Judge Krause, the ex parte meeting was not improper. That means that judge just gets to step in and rely on and defer to all of Judge Glanville's prior rulings. So Judge Krause is saying there is nothing to go back and look at because he didn't do anything wrong. The only thing wrong he did was defend himself in saying that he didn't do anything wrong. So, yeah. Right. Yes. So if she would have said it was misconduct, then they would be going back, and maybe not everything that he did, but everything related to the ex parte meeting, everything related to Woody's testimony, right? Some of the objections that were made, they would absolutely be going back to determine which, if any, or if all, could be considered. But quite frankly, if we get to the point of misconduct, it really doesn't matter because the whole trial is going away. So, April, they're not going to tell that jury nothing because they already know. They already know. What are they going to tell the jury, though? They're going to have to explain it. There's definitely going to be another argument about it, though. And the state is going to argue, but judge, no, to the new judge, no, we shouldn't be talking about the ex parte meeting because Judge Krause said there was nothing wrong with it. Judge Krause said it wasn't improper. So we don't need to, it's going to be a big thing. They're going to definitely be arguing about it. I agree. Our justice system is shameful. Whether you believe YSL is a gang or not doesn't matter. Precisely. It does not matter. The whole point of our criminal justice system is supposed to be, it doesn't matter whether you are innocent or guilty. It's supposed to treat everybody the same because we can never really know who's innocent or guilty. We can never really know for real. So everybody's supposed to be treated the same. And that way, what I think about who's guilty doesn't affect them and because what happens when I come to a conclusion that's wrong, right? And I've violated somebody's rights. It's not supposed to matter who you are, what you have, what you look like, or whether or not you're guilty. It's not supposed to matter. Justice is supposed to be blind. So, Mika, I don't know on what avenue, right? Like, I'm not sure. Not kidnapping. Leah said the jurors might have a case for kidnapping at this point. It's been a month, y'all. What did the judge? So, yeah, because I think what Judge Krause is doing is kind of trying to button up button up in a sense that close it out and we don't have to discuss it anymore. That's where I think it's going. She basically left the door open for this to happen again, just a different judge. I don't think so. I don't think she left the door. Well, I get what you're saying. She said there's no problem. There was no problem with ex parte meeting. So I guess you're right. Well, if another judge were to do it, we would still be back here. If another judge did it, they would be filing the same motions. We would be having the same argument again. Well, she would be another judge, actually. I take that back. Wait, did I just... Yeah, hold on. Let's go back. Judge Krause just heard the recusal motion. She's not the new judge. We'll talk about the new judge in a second. Yep, she handled her explanation with kid gloves. I agree. We all saw the transcript. How can it be said that wasn't inappropriate? Apparently, it can be said with a straight face. Apparently, that's how it can be said, with a straight face. Apparently. I think she's afraid of retaliation. Yeah. And that's legitimate, right? It's not even a real criticism of her that she's afraid of retaliation. That is a legitimate fear. And that is the point of Doug Weinstein's motion. That we don't want judges who are in this position and have to potentially deal with, because these are humans, right? They're not robots. So we don't want a judge who may have to deal with the consequences of making a tough decision like this to be afraid to make the right choice. The contempt order is done. It's moot at this point. There is no contempt order. It's just done because he's been recused. So Jamie, listen, if you catch it, please send it to me. I don't know. This wasn't streamed, apparently. I hate that it wasn't. I would have loved. It doesn't seem like there was a hearing, though. Seems like she just reviewed, the transcripts or whatnot and made a decision. But I'm really interested in what everything is going to look like starting tomorrow. They should be in court tomorrow because we need to discuss logistically what happens next. When is the jury coming back? We need to discuss all of that. Is there going to be another month that we're out because the new judge needs to catch up? There's a lot to be figured out. There's a lot to be figured out. But I expect they're going to be filing a motion for mistrial based on misconduct. And then the new judge is going to have to weigh in on her opinion on all of this. And now that it's flowing now, Judge Krause, her opinion is only valid in so as much as she dealt with the recusal. She's not the judge on the case. So she won't be hearing the motions for mistrial, the motions for dismissal based on misconduct. She's not going to be hearing any of that. So now there's going to be another judge that hears that, which is the new judge. Hey, sister. Y'all say hi to my sister. Sorry, my other sister is on. Y'all say hi, sister. Her name is Kuda Creates. She also has a business. Let me plug her while we're here. She's a creative, and she pretty much can make anything. Y'all will see it on her page if you go check her out. But yeah, so she does custom everything. I don't even know. She does literally custom everything. But yeah, so bye, April. Hate to see you go, girl. I'll see you next time. But yeah, so we know that the motions are coming, and this new judge will have to hear them. And the new judge's name, I just had it up just that quick. I forgot. Let me see. I think it was Shakira. Y'all remind me. It was Shakura Ingram. That's it. That was it. All right, so she's been a judge, looks like, since 2018. Damn. Getting a case like this from the beginning is a lot. It's a big case, and you know it's going to be a big case. But randomly getting assigned a case like this halfway through the damn case with all of this, I would hate to be her. Possibility of bail, I would absolutely be revisiting. I would be filing every motion I already filed. I'll be filing it again. But she can rely on all the previous cases. So now we got to deal with her having to address the ex parte meeting as well, and determining whether or not it was improper or it was misconduct. So she's going to have to do that. Then she's going to have opinions about his prior rulings. Because if they're able to bring up some of these, for example, bail, address bail again, she can either say, yes, I agree with what Judge Glanville said previously, or no, I think he was wrong, and these are the reasons why, and this is what I have to say about it. So will Judge Glanville still be subject to other forms of discipline, and when will we see that? It depends, right? If they file complaints, then those complaints have to go through, because he has due process too. They would have to go through the JQC, the Georgia Bar, if they're filed. I don't think anybody's going to be filing complaints. I don't think anybody's going to be filing complaints. And I think the most egregious thing he did was obstructing us getting all the information. So you can always ask a judge to reconsider. Not that loosely. That was a loose way of explaining it. But you can kind of, sometimes there's time requirements. But generally speaking, at least in Florida, you can always say, hey, judge, I want you to reconsider because you got the law wrong. Or I would like a reconsideration of this ruling. So I doubt they'll be doing it on everything, but they can absolutely revisit. And she has to say, no, I can't revisit this for whatever reason. It's already been ruled on. I agree with the prior ruling, or no, I disagree for XYZ reason. Anybody can file a complaint. Yeah, anybody can file a complaint. Yep. I don't know if she can turn the case down. I'm not 100% sure. So I know when I was a public defender, for the most part, we had to take cases unless there was some sort of like personal. It's very rare that happens. I think most lawyers and judges understand if this, it's just kind of a part of the game, right? You'll get some great cases, you'll get some bad cases. But again, this is for somebody who's ambitious, judge, lawyer, whoever, this is the case of a lifetime. Yeah. So if I were her, I would damn sure want to be. I would be like, yes, absolutely. Let's do it. Let's go. You know what? Jasmine, you're right. The judge before Judge Cross was like, no, y'all got it. She was like, no, Judge Belinda, I forgot the last name. Weinstein said he'll have a motion for mistrial and for bail. Absolutely. Absolutely. Yep. I'm sure he will. Yeah, she did. She recused herself. She said, nah, y'all got it. I don't want it. I don't want it. I don't want to be a part. I want nothing to do with it. Can't be mad at that. Can't be mad. Because I'm sure she understands that the recusal part is not going to be the end of it. It's not going to be the end of it. So it is what it is. Look at us, almost at 35K likes. Y'all are the best. Y'all are really the best. Yep. Media is definitely on demon time about this case. I agree. You know what? Danielle, you might be right. This case is full of comedy errors. It's no longer the career maker. You know what? I think the people who it was career changing for, like, it's kind of already happened. Like, we know who the showrunners are of the case. We've already kind of seen it. So, but I don't know. It's been surprising us all this time. Who knows? Who knows what'll happen when some of the other defendants, when their acts start coming up? I don't know. Maybe some other people will, pop out. Do I think they'll get bond? I think when it comes to bond, I am very cynical about what judges think about bond. My personal opinion is that there are plenty of judges that are afraid that if they release someone and that person commits another crime while they're out on bond, that it's going to reflect bad on them. And I think that a lot of judges, are afraid of that. And is that a real fear? Probably. But I'm a defense attorney, so maybe I'm biased, and I put that fear up against the presumed right to pretrial release, and the idea that we're all supposed to be innocent until proven guilty, right? So I don't know. Yeah, some of the charges aren't available for bond. So some of them have additional charges outside of the RICO charges. I haven't looked specifically. But yeah, that might be true, that some of the charges are non-bondable offenses. He ain't gonna do nothing but go straight to the studio and drop an album, as would I. Period. Danielle, take me to trial. Let's go. Thank you, Miss Baby Cakes. I appreciate it. And I absolutely expect to see Brian Steele in the next Young Thug video, maybe on the next red carpet. Who knows? Okay, let's finish out. We're on page 9 of 10. All right. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative. And let's just say failed. It was not objective. It was subjective, like he was talking about, this is what I recall, this is what I saw, this is what it was. Dispassionate. Hell no. He was very passionate about what was going on. It's clear he was fighting for his life. Insert R. Kelly. He was fighting for his life. Literally. It was very clear. Like, he felt strongly about what was going on, and he wanted to make sure that whoever heard this recusal motion knew from his perspective what happened. He was very passionate. All right. And non-argumentative. He was absolutely argumentative. Super argumentative. And non-argumentative is possible so that the judge is not reasonably perceived as a hostile witness or advocate. Absolutely, judge. Hands up. Don't shoot. Why are you upset with me? Why are you yelling, judge? He was hostile. And let me be clear. He did his best his temperament was steady, but the words that he was saying and the way that he was rebutting every single thing that Brian Steele or Doug Weinstein had said, it was super clear what he was doing. In presenting his record as to the recusal issues and ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from the further handling of this case. She threw him and us a lifeline in the same sentence, right? Literally, she threw us all a lifeline. Hold on, y'all. Let's see. Yep. Super partial. Partial like the opposite of impartial. Mm-hmm. Weinstein is definitely a big dog. Between Weinstein and Brian Steele, the way that they, y'all, I wish I could explain how complicated it is to be a strong advocate in the courtroom. Like I think I have a very strong personality, but you have to know when to hold them, know when to fold them. You got to know when to stand up strong. You got to know when it's not worth, the argument. But going blow for blow with a judge the way that both Brian Steele and Keith, I have to mention Keith Adams every time I talk about this, because Keith Adams multiple times, and more specifically the last time when this motion for recusal came up, Keith Adams, not unnecessarily, I think it was necessary, but he volunteered himself to the fire, right? Keith Adams was like, and judge, just so you know, the same information, I got that information too. So since we holding people in contempt, let's go. Take me to jail. That was Keith Adams. And that's important. And since you want to take my co-counsel to jail, just so you know, I'm not playing this game with you, Judge Glanville. You represent Young Thug. Since you want to do everything, since you got your fucking degree in my Monique voice, you do it. I'm not participating. We will not be doing it. No, thank you. Mm-hmm. Yeah, Keith Adams is, listen, I love me some Keith Adams. He's just the right amount of smooth, just the right amount of aggressive when necessary, just the right amount of, he gives me like, how can I explain it? Like you have to come to a conclusion about whether or not he thinks you're stupid. Like when he's asking you questions, does he think I'm dumb? Like is he asking me this question because he thinks I'm stupid? As in, is he dumbing it down for me, or that like what is he doing? You have to ask yourself that question as he's questioning you. Like, is he making a fool of me? Keith Adams is the man. He's definitely the man. Seasoned. Mm-hmm. Yep. All right, we're going to finish for real. This is what everyone already saw. Based on the foregoing, this court hereby orders as follows. Defendant Diamante Kendrick's motion to recuse Chief Judge Earl Glanville is granted. Caleb Bumpus' motion to quash the show cause order and or recuse Judge Glanville is denied as moot, meaning it's already been resolved because he's being recused. So we don't need to talk about it. Defendant Jeffrey Williams' motion to disqualify/recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall, come on y'all, before we get out of here, one more time in the comments, please let the church say shall. Shall. I'm impressed by your legal expressions. Thank you. I appreciate it. Let the church say shall. Let the comment section say shall. Word of the day is shall. The clerk of court shall reassign this case. Do you think the clerk of court is going to write back and say, I don't want to? No, because they shall. Because the court said that's what you got to do. Shall reassign this case using the court's case assignment procedures, which I believe is just a random program that reassigns randomly. That's my understanding. You shall, period. Hey, Martina. Yep. Right, because the clerk is going to follow the rules. And that's what we need. We need somebody following the rules. That's exactly what we need. How come the other attorneys didn't file a recusal motion? So they are under, and I love saying it, but I'm not sure exactly where it came from, but the Harvey rule, which in this particular trial means that any motion that one attorney files, everybody else is a party to the motion unless they decide they don't want to be. So that once somebody argues one thing, it is presumed that everybody's arguing it unless they come out and say, no, we don't want to be a part of that. We don't want to be a part of that. No problem. No problem, Jamie. Jerica said, if I was the next judge, I'll be on the beach with Jamie. I shall call in sick tomorrow. Yeah, so, okay. I feel like I gave y'all some of my thoughts already. But, yeah. So, Judge Krause tried to not really nip in the bud. She's only dealing with the recusal, so she can't really nip it in the bud. But she absolutely tried to get ahead of the misconduct allegations, right? This is not misconduct. This meeting was okay. She basically was like, now I wouldn't have did it like that. I probably would have did it in open court. But because he chose to do it as an ex parte meeting, there's nothing wrong with that. But what he did do that was wrong was defend himself. I don't agree with that at all. Again, we got to the right conclusion, but not for the right reasons. And I think that she tried to, or potentially like anticipated what is to come. And now we're going to deal with, yeah, Judge, you recused him and he's off, but all the meat that you didn't get into, we still got to address that. So Judge Ingram is going to have to deal with the details of that. But the defense, they're not going to be able to rely on, oh, Judge Krause found that he needed to be recused and she found that this was improper. They're not going to have that wind behind their wings, basically, from another judge. She took the wind from beneath their wings, and they're not going to be able to use that as an argument. They'll be able to argue it, but they won't be able to use a judge's order to kind of solidify that argument. So they're going to, if Judge Ingram disagrees, she's going to have to disagree. Damn, it just goes on and on and on again, huh? So now if Judge Ingram thinks that it was misconduct, she's going to have to disagree with Judge Krause. Over and over again. That's kind of where we are. So yeah, I don't agree with Judge Krause. I think that the ex parte meeting was problematic. I think they had no business in that meeting together with the judge and a sworn witness. I think it was super problematic. I think that the state recanted basically their argument about the whole Woody being afraid, because that is something that Ms. Love decided on her own without any evidence, other than, that's just how she feels. Yeah, those are my thoughts. That's how I feel. And I think there should be a mistrial. I think this case should go away. I think that it is a disservice to these jurors and to the defendants and to Fulton County, quite frankly, meaning everybody in Fulton County, because I don't know if anybody in here is from Fulton County, but y'all are paying for this trial. I think it's a disservice to everybody to continue with this trial, because it feels doomed, quite frankly. Like, what are we even doing? It feels very doomed. It does. Oh, and with prejudice. So Jamie's saying with prejudice. So as much as I would like it to go away with prejudice, I don't think we have that yet, right? Are they going to argue, yes, this was misconduct, it was intentional, et cetera, et cetera? They probably will argue that. But as it stands right now, we're not at the same level of misconduct, I guess we'll say, that we have, like, for example, in the Alec Baldwin case, where the damn prosecutor, y'all, I hate to go, but let's just go into it. Did anybody like watch that little section of the Alec Baldwin trial where the prosecutor took the stand? Did anybody see that? I agree, just based on the embarrassment. Yeah, so the Alec Baldwin trial, I'm going to keep it real short because this is about YSL, but that was crazy. In the Alec Baldwin trial, essentially, for anybody that doesn't know, Alec Baldwin is an actor. He was on trial for manslaughter after someone was killed and someone else was shot on the set of one of his movies. And the person who handled the gun was already convicted. Like the person who put the bullets in the gun, et cetera, has already been convicted. Apparently, someone who knows that lady that's already been convicted bought some bullets to the police saying, look, I don't know, but I think these are bullets that were used that are similar to the bullets that were on the scene. The state basically said, I don't want the defense to see this. And so they intentionally hid it, is the best way I can explain it. And it's crazier than I even thought. Not $40K. 40? Y'all, please. It's too much love for one night. I can't take it. I can't take it. But yeah, so that person, the prosecutor, basically hid the evidence. The prosecutor and the police. The day that this all came out, there was and I didn't even notice this. This all happened by like day 3. So this is all on a Friday. My plan was because I watched opening statements. I was like, I'll just catch up over the weekend, and then come Monday, I'll make a couple of videos and get everybody up to speed. Friday, the prosecutor who did the opening statement for the state, she resigned. She quit. The prosecutor quit in the middle of trial. Like, the prosecutor said, no, you do it by yourself in the middle of the goddamn trial. Okay, so I saw user 342 such and such. Please tell me your name. Please tell me your name. But yeah, a couple people did. I know, I think maybe one of the investigators, if I'm not mistaken, there was a couple people that resigned, but the prosecutor that did the opening statement, Eric, the damn prosecutor quit. That is, I don't even know how to, like, in the middle of the trial, which tells me that she found out something that she didn't know and she wanted no parts of it. Every video that I watched basically said this is a renowned prosecutor. She's well known, well respected. She fucking quit in the middle of a trial. And then the prosecutor that continued the case, she basically bulldozed her way on the stand so she could explain herself. After the judge was like, look, you ain't got to go up there. Just so you know. She went up there and called herself as a witness. I was shocked. I was shooketh, okay? And then got up there and proceeded to basically admit that she tried to explain it away, but there was no explanation. And then had to not admit, because she wouldn't admit it. The witnesses apparently were telling the defense attorney she was calling Alec Baldwin a cocksucker and I'm going to teach him a lesson. This shit is nuts. This is crazy. This is insane. It's insane, okay? This was out of control. Out of control. Eric, do you think it was her? Oh, you mean the one who resigned? Her conscience couldn't take it. It had to be. It had to be. Like, for a prosecutor to quit mid-trial? Man, I can't even stress. I can't stress. Thank you, Eric. Thank you. I can't see the name of the other person. User 45685449944. Thank you as well. Yeah, she did not want that Brady smoke. With no explanation at that. She quit with no, she didn't say, Judge, she just packed her shit and left. I quit. Y'all could talk to them. Huh? That's nuts. That's nuts. I agree, Bailey. I agree. Like, I'm a firm believer. I will walk away. mid anything, right? If it's not for, yeah, no. I'm big on having a clean and clear conscience. I will walk away. That's exactly how it should be. Bye. Y'all wanna cheat, y'all wanna lie, y'all wanna hide, you do it yourself. You're not about to have, and then you gonna have me and my career up there and do it. Nah, no thank you. No thank you. Mm-mm. I think that whatever they tried to keep like plausible deniability. Oh, I knew about the guy coming in, but I didn't know about the report, and there was no way. It was too many hairs crossed, and the defense attorney was really good at like catching it, basically. And this is why it's important to be on point, to be on P, what we call on P. Because if you're not, it can slip. It can happen so quickly that something slips by you. And the defense team was really good at catching it, flipping it, and addressing it aggressively. Because that's the other thing. As a defense attorney, you're standing between your client and the government. If something bad happens and you don't raise hell, then they won't think it's that bad. It's very rare, like, that a judge, first of all, nobody's paying as close attention to what's going on as you are as a defense attorney. Like, no, like literally nobody is. So, police investigators don't be doing their jobs. To Olivia Benson would never. Olivia Benson would never. I didn't see her interview. Please DM it to me if you have it. If you have like a link, but Yep. How many people it happens to in the dark? I agree. In the dark all the time. It's a blessing. It's a blessing to be, a person that's able to kind of bring the truth to the light sometimes. But it's even more amazing when you watch it happen, like in the public's eye. Yep. But yeah, so that's Alec Baldwin. I'm sure we'll continue to get, news, because I truly believe that we're gonna start to see appeals from the other young lady that was convicted. Like I'm sure we're gonna see appeals. So we'll definitely talk about that in the future. So you could probably go. It was only like 3 days. We only got like 3 days in, so you can probably go back and watch it like in a day or two, quite frankly, because a lot of it was downtime. So it's not that much to catch up because it was only like 3 days worth of trial. But yeah, nobody's charged with purposely putting the bullets in there. Just basically negligence, manslaughter. Nobody's charged with intentionally doing anything. I agree. Yep. Having trials streamed, and there are courtrooms across the country that have their own YouTube pages that stream their court hearings from their YouTube pages. 3 days versus 8 months. Now, honestly, I just think there's so much in the YSL trial. There's no way that with the way that they put this case together that we could get a shorter trial. I think it's more about the way they structured this case than anything. And watching the trial and realizing that it's this long and it's basically based on hearsay, gossip, and a couple people with significant motives to lie is like bonanzas. Right. Yak, I think there's 5 of them total that got indicted with the murder. Yeah. Stillwell, yes. I believe Shannon Stillwell also was charged with like a separate charge as far as the murder outside of the RICO. I believe so. But yeah. Yep, that's kind of where we at, y'all. So the unfortunate part that, so I think the second people that is twofold. The second set of people that are going to trial, they get the benefit of seeing the state's case in advance, right? Like, I'm sure their defense attorneys are watching just like everybody else because they get to see the state's case. But the negative side is the state gets to correct their mistakes the second time over. So it's completely different proceedings, like completely different. So Young Thug and the people on trial now could get off, literally, not guilty. And then they could go to trial in the second case and they could be convicted. It's completely separate proceedings. One has nothing to do with the other. Now, my thoughts, if Young Thug, if Shannon Stillwell, if those folks get off, I think they may let go of the rest, but I could be wrong. They could just say, no, we got to get somebody. Yeah, Marquavius Huey has the most charges in the indictment. We've rarely heard about him. Rarely. He's also not a convicted felon. I think he has minimal prior arrests as well. So it's really interesting that he has the most charges and he's involved in the most acts. Yeah, we haven't heard much of nothing about him. Much of nothing. Yep. That's probably the saddest part of this case, Jamie. Dexter Montgomery is a gentleman that was shot in the head, and he didn't even really understand why he was there. He was thinking he was coming to testify to have the people that, shot him be convicted. And truth is, it had nothing to do with that. There is no act it's not a specific act, essentially, in this case. They just brought him there so we could, I guess, see the ramifications of his injuries. And it was sad. Real sad. Really sad. He can't remember much, right? He has memory issues. It was just his testimony that was for no other reason to evoke sympathy. That was it. Yeah, he had no clue that somebody had already, I think, pled guilty. I don't think they went to trial. He didn't even know that the person that actually pulled the trigger was already convicted. How do we end up with a separate trial for the other 6? They were severed. So for whatever reason, and there's a bunch of different reasons we can argue that you can argue for a severance, but essentially their attorneys argue that for whatever reason, essentially that they wouldn't get a fair trial is generally the reason that they should have a separate case. And they did. Yes. Yeah, he'd already served time. Yeah, imagine that their strongest evidence is supposed to be the witnesses who, not just any witnesses, the witnesses that are directly involved with YSL, they're supposed to be the strongest witness. Tell anybody. If anybody can think of one member of YSL or a person that is affiliated with YSL, even just closely affiliated with them, that has given them like great testimony or made their case, please point it out to me. I don't see it. I don't see it. But yeah, so that's where we stand now. We have a recused judge, a new judge. We still don't know what's next as far as, when we're getting back into it. But we are nowhere near close to having the jury just come back. There's still going to be plenty of motions to be filed, plenty of things to happen to get this judge situated with this case. Yep. All of them. And that's probably the best way to put it, Bailey. Every YSL witness gave minimum for their plea, and that's all. They gave the least amount of information they could to successfully take their plea or avoid, being prosecuted any further. And that's that. Yep. We're at 48K. I was going to wrap it up, but I'm going to give us a couple more minutes because now I have a 50K goal, and I believe y'all can get me there. And I really appreciate y'all, really and truly. Yeah, rich versus poor is a really good way to put it, Eric, honestly. Truly. Yeah, that's probably the best way to put it when it comes to this, because money will get you a better defense and even a better prosecution sometimes. Now, in this trial, in the YSL trial, we got a good mix, right? We have somebody who is wealthy or has money, and then we have a bunch of people that are poor. So we got a good mix in this trial. But yeah, I agree. A good lawyer can move a mountain. Do I think they've proven the RICO? No. I think the case, they spent a lot of time proving that YSL, they're affiliated with YSL, that they're a gang, that they're associated, blah, 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 et cetera, et cetera. I mean, we all knew that. Like, we all could have guessed that. But the connection they have to make is that these people are committing crimes on behalf of YSL, and that they're doing it on behalf of Young Thug. They have not proved that. They have not proved that these are crimes that are committed for the sake of YSL. And maybe the closest thing act that they have that would suggest that is probably that part of the prosecution is falling apart terribly. Terribly. We got to 50K. Y'all, thank y'all so much. Thank y'all. I really appreciate it. I really do. Oh yeah, Lil Rod. So he apparently was convicted of murder already and is serving a life sentence already. He's just kind of sitting there. Haven't heard his name come up, not once yet, I don't believe. Yeah. Thank you, Leah, or Leia. I'm guessing it's Leah. Thank you, Leah. I appreciate it. I really do. If there's a mistrial, can other defendants appeal? No. So when you take a plea, if there are 100 rights associated with going to trial, when you take a plea, you give up like 95 of them. When you take a plea, you like severely limit your right to appeal most things, because it's a bargain. Essentially what you're saying is, I'm willing to give up all these rights to be done with this case. So not really. Is double jeopardy at play? Double jeopardy is always at play, theoretically speaking. We talked about this a little bit earlier. Once a jury has been sworn, double jeopardy is triggered in general, right? It means jeopardy could be an issue. But just because we're in trial doesn't mean that there could never be a second trial. Like, there are plenty of people that have gone to multiple, 2, 3, 4 times, end up in a trial. So the question is really how the case resolves. If they're able to get resolution in this case, that's a verdict. If we get a verdict, it is what it is, right? If the verdict is either guilty, well, if it's guilty, we could still end up with a new trial if the defense necessarily positively appeals one, right? If they get a good outcome as far as an appeal. But generally speaking, if we get a verdict, double jeopardy is like, there is no trying it again unless the defense is able to uncover some kind of injustice that requires another appeal. But yeah, every time you swear in a jury, double jeopardy is an issue. Do I see a mistrial? It's hard to say. I think there should be a mistrial, but I don't know if we're going to get there, because now we have another judge and we have no idea what this judge thinks about this case. But they're going to be trying real hard to get a mistrial. I can promise you that. How far back are they going? It's hard to say. I don't know. Are they just going to say take the stand? Kenneth Copeland? Are they going to tell Woody to start over? I don't know. I don't know. It's hard to say. Maybe if it comes up again, maybe not, because it's so hard. Honestly, it's really hard to say. I hope he doesn't have to start over either. But I could see where they say, look, just so that it's clean and clear, we're gonna start Woody's testimony from the beginning, because part of his testimony was affected by, this ex parte meeting and these motions, et cetera, blah blah blah. I could potentially see that, but it's really hard to say. He is gonna flip his shit if he got to start over. I could only imagine. I could only imagine. Can she overturn prior rulings? Potentially, it's possible. I don't know if it's likely, but it's definitely possible. I can hear Woody now. Play the recording, period. Play the recording. I already said that. I already answered that. I can hear him now. Good point, right? Judge Glanville and Miss Love, they said it, openly, that they've had prior cases. I don't know if she practiced in front of him, as a prosecutor. A lot of times they're, at least in Florida, it's like that. At least in Miami, I'll say in Miami, and in Broward, where you're assigned a courtroom. So you might be in front of one particular judge for, 6 months, a year, 3 months even. And it seems like Judge Glanville was the judge that Miss Love was assigned to at one point. That was the energy that I was getting. And I feel like I think they might have said that at one point, but I'm not 100% sure. Let's see. Did I follow the YNW Melly case? Jamie, I can't wait for the YNW Melly case to come back. I can't wait. Yes, I followed it thoroughly. I can't wait for it to come back. Every once in a while, I'll just check. I suspect when it pops back up for real, we'll see. We'll see it. But yes, I can't wait. One day I was in Broward in court, and tried to pop in and see what was going on. It was the day that the detective with the mask and all of that mess was going on. So we shall see. Yeah. Lord, I wish I could be a fly on the wall when they tell Woody about the judge. She gonna say, y'all know they dirty in Fulton County. That's what Woody's gonna say. On the YNW Melly case, it's another one that needs to go. Yeah. I don't know. I don't know if I have an opinion on whether or not he did it. But again, from my perspective, that's not what we're talking about. We're not talking about whether or not he did it. We're talking about what the state has done to prove their case and whether or not they followed the law. And, woo, Lord. That Borland looks guiltier than Melly. Yeah, and it's crazy. It's insane. But it's so easy to come to a conclusion when you think you have all the facts. And I have to remind myself, we only know what the state has shown us. The defense does not have to tell us everything. We only know what the state has put together for us. Yeah, I agree. Exactly. Woody is on TikTok and IG just like the rest of us. I'm sure he found out. Yep. I agree. Oh my God, I forgot about the fingerprint. Oh God, I'm just getting a headache thinking about that trial. That trial it was nuts. He also has a new legal team. There was, I think, maybe one of the attorneys is still on there, but he has different lawyers this time. And the lawyers I loved his defense team from the first trial. So I don't know, what's going to happen. But I will tell you this, they need to get the audio in that courtroom together because it's terrible. Best life. Woody is living his best life right now. He is enjoying life. He is trying to build, his reputation outside of this trial, which I love that for him. We got to remember these are humans. They have lives, they have kids, they have families. And yeah, he's trying to build his life outside of this trial. Oh, yes, there was a lot of inconsistencies and crazy stuff going on in that YNW Melly trial. Yeah, I'm having flashbacks. Yep. I agree. He's now extra famous, but I need him to stay on the right side of the law. Crime scene reconstruction was a joke. A joke. All right. All right, y'all. I think this is it for tonight. Do I think there'll be a mistrial? I'll wrap with that. I think there should be a mistrial. I think there should be one. I don't know if we'll get one. I think there should be one now, and I think there's probably been maybe 2 other times in the trial where there should have been a mistrial and we didn't get it. I don't know. I don't know anything about this new judge. I don't know what to expect. I don't know what kind of judge she is. I don't know. But I do think there should be a mistrial. Yep. DM me I'm sorry if you DM me already, Jada. I know I told you last time too. Just send me another one so that it goes to the top. I'll be getting DMs all day and I'll be trying real hard to sort through them. Please send me another one so you'll go to the top and I'll go look at it now. Yep. You can send me one on TikTok. All right. And we're at 52K likes for the night. I really appreciate y'all. Like I said, I enjoy doing this work. For anybody that's still on here that has not already met me, if you will, my name is Arian. I'm a criminal defense attorney in Miami, Florida, owner and managing attorney of the White House Law Group, where we handle criminal defense cases, civil rights cases, and some personal injury cases. If you are ever in need of an attorney in Miami or the state of Florida in general, please contact me. You can email us at info@whitehouselawgroup.com or call us 305-697-2353. I really appreciate y'all. Wait, I missed it, Leah. I missed what you said. But yeah. All right. So that's pretty much it for tonight. Also, if y'all see anything that you're interested in discussing as far as legal cases, I try not to do too much politic talking, but sometimes you just got to let it out. And I'm going to talk about what I want to talk about. So, yeah, if you see anything interesting enough that you would like for me to discuss, please send me a DM. Let's talk about it. Is it fair to assume, and I'll answer that question before I get out, I promise. Yes, Jordan, sure, send me a DM. Yep. Is it fair to assume that court isn't usually this dramatic or entertaining? No, at least not in Miami. It's not fair to assume that. There's always something going on. And I'm a lawyer, so I have friends that are also lawyers. So when it's not one of my cases, it's one of my friends' cases. There's always something happening, likely because this system is trash. That's probably why. That there's always something going on. Maybe not this dramatic all the time, but you can get a little sprinkle of drama pretty much every day. Yep. Pretty much. But yeah, all right. Okay, Jada, I'll go check it now. And Jordan, go ahead, send me one as well. It was wonderful chatting with y'all. I have abandoned my husband for the night, so I'm going to go check on him. And I will talk to y'all another time on another live. Until then, y'all be safe. And yeah, have a great night.